Today, I am trying to give a small lecture on jurisprudence, the nature and scope of jurisprudence. First and foremost, we will see what is the definition or meaning of jurisprudence. The word jurisprudence is derived from the Latin word jurisprudentia, which denotes the knowledge of law. In Latin, jure or juris means law or legal, and prudentia means skill or knowledge. In French law, law jurisprudence is the term applied to the body of law built by the decisions of particular courts. I repeat once again, in French law, law jurisprudence is the term applied to the body of the law built by the decisions of particular courts. In France, jurisprudence called la philosophie du droit. That is the philosophy of rights, and that is of law. In the abstract sense, the term law, in Germany, we have term Rechtsphilosophy. That is the philosophy of rights, that is of law in the abstract sense. So, the celebrated Roman jurist Alfred, 180 to 228 AD, he defined the jurisprudence, the knowledge of things, human and divine, the science of just and unjust. Now let us see what is the definition that is given by Cicero. Cicero said, the philosophical aspect of the knowledge of law is jurisprudence. According to Cicero, the study of law must be rooted in the depths of philosophy, and by an examination of the human mind and social nature of man, the deep principles of true justice may be embedded in our laws, without which the rules of positive law are but of the trivial importance. According to Salmond, the jurisprudence may be defined the science of civil law. Simple definition Salmond has given is that the science of civil law. Austin refers the jurisprudence as a philosophy of positive law, whereas Holland defined jurisprudence as formal science of positive law. Formal science of positive law. According to Gray, jurisprudence is the science of law, the statement and systematic arrangement of rules followed by the courts and the principles involved in those rules. Now let us come to the modern writers. So Professor Allen has defined the jurisprudence as the scientific synthesis of essential principles of law. Pattern. It is a particular method of study, not of the law of one country, but of the general notion of law itself. According to Professor Keaton, jurisprudence is the study and the systematic arrangement of the general principles of law. And P.J. Fitzgerald, he stated that jurisprudence is the name given to certain type of investigation into law, an investigation of an abstract, general and the theoretical nature which seeks to lay bare and essential principles of law and legal system. Now let us see Professor Jolowigs. Jurisprudence is the general theoretical discussion about law and the principles as opposed to the study of actual rules of law. These are the modern writers. Some more modern writers I may be permitted to refer. That is Julius Stone. Jurisprudence is the lawyer's examination of the precepts, ideals, techniques of the law in the light derived from the present law and in the light derived from the present knowledge in discipline other than the law. Lord Cross says that jurisprudence is the study of lawyers' fundamental assumptions. I repeat once again, Lord Cross says that jurisprudence is the study of lawyers' fundamental assumptions. And Sculptor states that jurisprudence is the sum total of the techniques of legal reasoning and of the general principles to be applied to individual cases. Carl, jurisprudence means any careful, sustained thinking about any phase of things legal. If thinking seeks to reason beyond the practical solution of any immediate problem in hand, it includes all types of honest and thoughtful generalization in the field of law. Dr. Edward Jenks said that the new jurisprudence states that a treatise on jurisprudence may go into the minutest particulars or to confine it to the most general doctrines, and either cases derives its name. What is essential to it is that it should be an orderly scientific treatise in which subjects are duly classified and subordinated. So that, basing on the above definitions, both ancient and modern, who may define the jurisprudence as the study of fundamental legal principles, including philosophical, historical, and social basis, and an analysis of legal concepts. The jurisprudence considered as the study of the fundamental legal principles and is concerned with the normative and not merely positive. It is concerned not merely with the actual but also with the ideal. So it may be considered as a philosophy of law and the quintessence of law. We may conclude by saying that jurisprudence is the science of law dealing with profound legal principles which influences and changes human conduct from time to time. Now, jurisprudence as a science of law. Science is primarily a quest for knowledge, that everybody knows it. Science is primarily quest for knowledge. Science is the systematized knowledge of any subject of intellectual inquiry. Science is also an objective, logical, systematic method of analysis of phenomena devised to permit the accumulation of reliable knowledge. So, science is more precise and more concerned with the truth. We have seen what is science. Now, jurisprudence is the knowledge of things, divine and human. The science of what is right and what is wrong. This we can found in Black's Law Dictionary. So, the jurisprudence of common law of England is a science of social and comprehensive. So, jurisprudence is the science of law which treats the principles of positive and substantial law. and the legal relations. Its functions is to ascertain the principles on which the legal rules are based, to classify them in their proper order and show the relation in which they stand to one another. It is not merely a history of law. Jurisprudence is not merely an history of law. Its functions is to separate essential elements of legal principles from historical accidents on a comparative study of the legal institutions of various countries. It is no direct concern with the questions of moral or political policy. But when new and a doubtful case arises to which two different rules seem, when taken literally, to be equally applicable, it may be, and often is, functions of jurisprudence is to consider ultimate effect which would be produced if each rule were applied to indefinite number of similar cases, and to choose that rule when so applied as will produce the greatest advantage of the advantage to the community. Austin calls jurisprudence as the science of law. Solomon calls it a science of civil law. Holland calls it the formal science of positive law. Arrett calls it as a scientific synthesis of essential principles of law. Jurisprudence, being a science of law, deals with the abstract principles. The end of jurisprudence, as stated by Moyer, is the general, the same as that of the all science, a complete grasp, a systematic penetration of its subject matter of the power of the following most general propositions into the minutest ramifications, and inversely ascertaining from the most concrete case, though all immediate stages of thought, the principles which it governs it. David Hume